All right, let's jump right into this focused revision explainer. If you're in the thick of your CA finals prep, you know the Companies Act can be, well, a bit of a monster. So today, we're going to tackle a really critical piece of it, the appointment and qualifications of directors. We'll break down all the key provisions you absolutely need to know. So here's our roadmap. First, we'll nail down the legal position of a director. Then, we'll get into the nitty-gritty of building the board under Section 149. After that, we'll unpack the core mechanics of appointment and rotation in Section 152, cover the must-knows about the director identification number, and finally, we'll look at some of those special appointment cases. Okay, first things first. Before we even talk about how to appoint a director, we've got to understand their fundamental legal role. I mean, what exactly are they in the eyes of the law? You know, the Act itself gives a surprisingly simple definition. A director is just an individual appointed to the board. But don't let that fool you. See, a company is what we call an artificial person. It can't act by itself. It needs actual people, the directors, to be its brain, its hands, its voice. And that simple fact leads to a much more complex legal reality. This is where it gets really interesting. A director basically wears two crucial hats at all times. On one hand, they act as an agent. Their actions can legally bind the company in contracts and deals. But on the other hand, they're also a trustee. This means they're in what's called a fiduciary position, which is just a fancy way of saying an office of absolute trust. They have a duty to protect the company's assets, its money, everything. It's this powerful combination of action and guardianship. So, now that we know what a director is, let's talk about how we actually build the board. Section 149 is our blueprint here, laying out all the essential rules for the board's composition and size. Okay, this table, this is pure exam gold, so really pay attention. The minimums are straightforward. 3 for a public company, 2 for a private one, and just 1 for a one-person company. The maximum for all of them is set at 15. But, and this is the key thing to remember, a company can go past 15 directors. They just need to get their shareholders' permission by passing a special resolution. But it's not just about the total number of directors. The Act also pushes for diversity on the board. For certain types of companies, having at least one woman director isn't just a nice-to-have. It is a legal requirement. So who exactly does this apply to? Well, first off, it's simple. Every single listed company. No exceptions. For the other public companies, it kicks in if they cross one of two big thresholds, either a paid-up share capital of 100 crore rupees or more, or a turnover of 300 crore rupees or more. You've got to lock those numbers into your memory. And the last piece of the board composition puzzle is the residency requirement. Every single company, no matter the type, has to have at least one director who qualifies as a resident. And the magic number you need to remember for this is a stay of 182 days or more in India during that financial year. All right, let's get into the procedural heart of this whole topic, Section 152. This is where we find the rules for how directors are formally appointed, and more importantly, the absolutely critical concept of retirement by rotation. Before anyone can even be considered for a directorship, there's a clear, non-negotiable 3-step process. Step 1, they need it in. We'll talk more about that in a bit. Step 2, they have to declare that they aren't disqualified under the Act. And Step 3, they have to give their formal written consent using Form DIR-2. Okay, heads up. This is a massive exam topic, retirement by rotation. The whole idea behind this is to give shareholders regular oversight and to prevent the board from becoming stagnant. For public companies, the rule is this. At least 2/3 of the total number of directors must be rotational. That just means their positions are subject to this whole rotation process. But hold on a second. That doesn't mean 2/3 of the board just gets up and leaves every single year, right? I mean, that would be total chaos. So the real question, the one you need to know how to answer, is how do we get from that big 2/3 number to the actual number of directors who have to retire at the annual general meeting? And here's our answer. Every year, it's 1/3 of that group of rotational directors that has to retire. So you can think of it as a 2-step calculation. First, you figure out the 2/3 who are rotational, and then you take 1/3 of that group. The Act is also helpful and tells us to just round to the nearest whole number. Now, this slide makes that calculation crystal clear. Let's just walk through this example together. So, Kopgada Advisory has 12 directors total. First, we take out the non-rotational ones, in this case, 2 independent and 1 nominee director, which leaves us with 9. Now, the number liable for rotation has to be at least 2/3 of that, which is 6. And finally, 1/3 of that group has to retire, which brings us to our final answer, 2 directors. This 4-step process is exactly how you should approach these problems in your exams. Okay, next up, we have to talk about the absolute entry ticket to becoming a director. I'm talking about the Director Identification Number, or DIN. Without this, you literally can't even get in the game. So what even is a DIN? It's basically a unique ID number that the central government gives to an individual. Think of it like a permanent license to be a director. The rule is incredibly simple and strict. No DIN means no directorship, period. Here are the key facts you've just got to remember about DIN. The application is all done online using Form DIR3. A person can only ever have one DIN, and it's good for their entire lifetime. As soon as you get it, you have to tell every company where you're a director, and then it's the company's job to inform the registrar. It's a very clear chain of communication. All right, let's wrap this up by looking at some of the special cases. I mean, what happens when a director is needed outside of the normal appointment process at a general meeting? Well, Section 161 gives the board itself the power to make certain appointments to handle specific and often temporary situations. Now, as long as the company's articles of association allow for it, the board can appoint these 4 types of directors: an additional director, an alternate director, a nominee director, and a director to fill what's called a casual vacancy. And each of these serves a very specific and distinct purpose. This slide right here highlights a difference that trips up so many students, so pay close attention. Look at the terms of office. An additional director is purely temporary. Their term ends at the very next AGM. But a director appointed to fill a casual vacancy, say because another director resigned or passed away, they effectively step into the original director's shoes and serve out the rest of their original term. It's a crucial difference. And the role of an alternate director is also super specific. They're just a temporary substitute, a stand-in. And the trigger for their appointment is very clear. It's when one of the original directors is going to be out of India for a period of at least 3 months. So after going through all these rules, what's the big picture here? The Companies Act provides a very detailed framework, a complete rulebook for appointing directors. But what I want you to remember, for your exams and for your career, is that the real goal isn't just about ticking boxes for compliance. The true challenge is using this framework to build a board that is dynamic, that provides real leadership, and that drives growth. Mastering these rules is just the first step. Good luck with your studies. If you're gearing up for this CA final, you know that the rules around company directors are absolutely critical. So today, we're going to break down the key sections from the Companies Act that you have to know, from how a director gets appointed all the way to their most basic duties. This is your essential guide. So let's kick things off with a pretty big question. How do these incredibly powerful boards of directors actually get put together? Is it really just a numbers game where whoever has the most votes wins, or is there more to it? You guessed it, it's way more than just a vote. It's actually a delicate balancing act. The Companies Act of 2013 sets up this whole framework to balance the immense power of the majority shareholders against the need to protect a minority. And it's all governed by a very strict set of rules. All right, here's our roadmap for this explainer. We're hitting 6 crucial topics. We'll start with fair representation, then get into who can't be a director. We'll look at the limits on directorships, the role of the independent director, how they're picked, and finally, we'll wrap up with a director's core duties. Let's dive right in. First up, Section 163. Now, this section is all about one thing: protecting the minority voice. Think about it. Without this rule, shareholders with 51% of the votes could appoint every single director, completely shutting out a huge 49% chunk of the owners. Section 163 is designed to stop that from happening. And the tool it uses is called proportional representation. It's a game changer. Instead of the usual winner-takes-all system, this method ensures that if a group owns, say, 30% of the shares, they get to elect about 30% of the directors. It literally guarantees them a voice on the board. Okay, now for the details you absolutely need for your exams. First, this isn't automatic. A company has to explicitly put it in its articles. Second, it covers at least 2/3 of the board. These appointments are made once every 3 years. And here's the kicker. Section 163 has an overriding effect, which means it overrules any other conflicting part of the act. That's a huge point to remember. Next up, Section 164.
You can think of this as the bouncer at the club door. It's not enough to get elected by shareholders, you also have to be legally allowed to be a director in the first place. This section lays out all the red flags that get you barred from the boardroom. The law splits these disqualifications into two really neat categories, which makes it easier to remember. Subsection 1 is all about personal issues, things related to you as an individual. But subsection 2 is about the company you keep. You can get disqualified because a company you're a director of messed up. So under the personal disqualifications, you have the obvious stuff, right? Like being of unsound mind or insolvent. But pay close attention to the conviction rules. If you're imprisoned for 6 months or more, you're banned for 5 years after you get out. But if the crime is serious enough to get you a sentence of 7 years or more, that's a lifetime ban. And of course, the absolute basic. You've got to have a director identification number, a DIN. No DIN, no directorship. Now, this is where directors really feel the heat. If a company you're on the board of fails to file its financial statements for 3 years in a row, or if it defaults on paying back deposits or dividends for over a year, you personally get disqualified. And the consequence is massive. You're banned from being a director in any company for 5 years. It's how the law forces directors to pay attention. Okay, so let's say you're qualified, you're clean, you're ready to go. But how many companies can you actually serve? That's where Section 165 comes in. It's all about making sure directors aren't spreading themselves so thin that they can't do their job properly. The absolute top line number you need to remember is 20. A person cannot be a director in more than 20 companies at once. And yes, that includes any alternate directorships. 20 is the hard ceiling. But inside that limit of 20, there's another really important sublimit. The max number of public companies you can serve on is 10. And keep in mind, for this rule, even a private company counts towards the 10 if it's a holding or subsidiary of a public company. It's a key detail. Let's move on to a very special kind of director, the independent director, covered under Section 149. These folks aren't just there to vote. You should think of them as the board's watchdog, the guardian of corporate governance. So who needs one of these watchdogs? Well, for listed companies, it's easy. At least 1/3 of the board must be independent. For other public companies, just remember this simple rule: 10, 100, 50. If the company has paid up capital of 10 crores or more, or turnover of 100 crores or more, or its total loans and deposits are over 50 crores, it needs at least 2 independent directors. So what exactly makes someone independent? Well, the first big test is all about money. An independent director can't have any major financial connection, what the law calls a pecuniary relationship with the company, other than their director fees. This ensures their decisions are unbiased. And the second major test is about personal relationships. They can't be a promoter of the company, now or ever. And they can't be related to any of the promoters or other directors on the board. This is all about preventing you scratch my back, I'll scratch your situations. Now, an independent director can't just stick around forever. They can serve for one term of up to 5 years. If the shareholders agree through a special resolution, they can be reappointed for a second 5-year term. But after that, they're out. There's a mandatory 3-year cooling-off period before they can have anything to do with the company again. Okay, so that raises a good question. Where do companies find these qualified independent people? Well, Section 150 lays out a formal process, and it all revolves around a centralized databank. It's a pretty clear path. If you want to become an independent director, you have to get your name into this official databank. That means applying online to the Indian Institute of Corporate Affairs and passing an online test within 2 years. Once you're in that databank, companies can find you and start their own vetting process to bring you on board. And that brings us to our final section, Section 166. This is huge. It basically lays out the fundamental duties of every director. You can think of it as their North Star, their ethical compass for every decision they make. And these are the non-negotiables. You must follow the company's articles. You have to act in good faith, not just for the shareholders, but for everyone involved. You have to be careful and diligent. You must avoid conflicts of interest. Never use your position for personal profit. And, this is an interesting one, you can't just hand off your job to someone else. It's your personal responsibility. And believe me, these duties aren't just suggestions. If a director breaches any of these duties under Section 166, it's not a warning letter. It comes with a hefty financial penalty, starting at 1 lakh rupees and going all the way up to 5 lakhs. The law takes this very, very seriously. So we've walked through the rules of the game, right? The qualifications, the limits, the duties. But that leaves us with one final thought. The law gives us the rule book. But what's that one quality, that thing you can't write into a law, that truly makes a great director? Something to think about. Good luck with your studies.
You know, the director's chair is a real seat of power and responsibility in the corporate world, but we almost always talk about how people get there, not how they leave. So today, we're going to look at it from the other side. We're exploring the critical and sometimes pretty dramatic ways a director's time with a company comes to an end. It seems like a simple question, right? But the answer is actually way more complex than you'd think. Is a director's departure just a personal choice? Is it a matter of company rules? Or can it be a full-blown rebellion from the very shareholders they're supposed to represent? Let's dig into the legal realities behind what it takes to empty that chair. So, here's how we're going to break it all down. First, we'll set the stage a bit. Then, we'll dive into the three main ways out: the automatic exit, the voluntary one, and the forced one. And finally, we'll look at what happens afterward, the crucial aftermath, and the systems of accountability that hold it all together. Okay, so let's get right into it. Getting out of that director's chair isn't as simple as just packing up your briefcase and walking away. Nope. Company law is incredibly specific about how this works. The law lays out 3 and only 3 specific paths for a director to leave: vacation, resignation, and removal. And trust me, these aren't just fancy corporate buzzwords. They are legally defined frameworks, and each one has its own unique set of rules, triggers, and consequences. Let's start with our first path, vacation. Now, this is not the fun kind with beaches and cocktails. In legal talk, vacation means the office becomes empty automatically. The director literally has no say in it. If certain conditions are met, boom, the seat is vacant. End of story. And what's really interesting here is just how many different things can trigger this. It could be something as simple as just not showing up. If you miss every single board meeting for a whole year, doesn't matter if you had permission or not, you're out. Or it could be something much more serious, like a legal disqualification or getting caught in a conflict of interest. These rules are really there to ensure a director is actually engaged and acting with integrity. But the law isn't totally ruthless. It allows for due process. Take a criminal conviction, for example. A director doesn't get tossed out the second a guilty verdict is read. You can really see the legal buffers here. There's a 30-day grace period to file an appeal, and as long as those appeals keep getting filed on time, the vacation of the office is basically put on pause. And you better believe there are consequences for ignoring the rules. If someone keeps acting like a director after their position has legally become vacant, they're looking at a pretty hefty fine, anywhere from 1 lakh up to 5 lakh rupees. So yeah, ignoring an automatic vacation is a very, very expensive mistake to make. All right, let's switch gears to the second path, which is probably the one we're all most familiar with: resignation. This is the voluntary exit, where a director decides on their own to step down. But even when it's their choice, there's still a formal process you have to follow. So it all kicks off with a written notice from the director. As soon as the company gets it, the board has to formally acknowledge it. And that's when a very important clock starts ticking. The company has exactly 30 days to get the official paperwork filed with the registrar of companies. And check this out. The director also has the option to send their own copy directly to the registrar, which kind of creates a personal official record of their departure. This is such a critical detail. So when is the director officially out? Well, the law is crystal clear on this. The resignation takes effect on the day the company gets the notice, or on a later date, if the director puts one in their letter. It's always the later of the two. This is so important because it means a director can't just backdate their resignation to try and dodge a problem. It's all about preventing any legal gray areas. And this is probably the single most important thing to remember about resigning. Stepping down does not wipe the slate clean. This quote says it all. A director is still on the hook legally for anything that happened on their watch. Resigning is an exit from the job, for sure, but it is not an escape from accountability. And now, for the path that's usually the stuff of corporate dramas: removal. This is the forced exit. This is when a director is actively pushed out of their seat, whether they like it or not. It's an incredibly powerful tool, but it's one that isn't used lightly. So there are basically 2 major forces that can remove a director. First, you've got the owners of the company, the shareholders. Second, you have a legal body called the tribunal.
You can think of it as a specialized court for corporate issues, and it usually steps in for really serious stuff like mismanagement. Both of these are incredibly powerful checks on a director's authority. So how much power does it take for shareholders to even get this process started? You might be surprised. The bar is set pretty low. All it takes is members holding just 1% of the total voting power or owning shares worth at least 5 lakh rupees. That's it. That low threshold makes this a genuinely accessible tool for shareholders, not just some theoretical power they have. But it's not a witch hunt. The process has fairness built right into it. The director has to be notified, they have the right to speak at the meeting where their removal is on the agenda, and they can even write up a statement to be sent out to all the shareholders. It's that fundamental principle, the right to be heard. But shareholder power isn't absolute. And this is a really important exception. Directors who were appointed by the tribunal can't just be voted out by shareholders. Same goes for directors elected through a system of proportional representation, which is a special voting method designed to make sure minority shareholders get a voice on the board. The law basically shields them from being easily ousted by a simple majority vote. So a director is out, one way or another. What happens next? Does the company just grind to a halt? Well, this final section is all about the aftermath and the mechanisms that are in place to make sure the company keeps running smoothly and transparently. I mean, it sounds like something out of a movie, right? A corporate doomsday scenario. What if every single director resigns or gets disqualified at the exact same time? Does the company just vanish? Nope. There's a legal safety net. The law actually anticipates this crazy scenario. The company's original promoter, or if they're not around, the central government itself will step in and appoint temporary directors. This makes sure the ship is never left without a captain, even in a total crisis. So how is all of this movement tracked? There's something called the Register of Directors. And this isn't just some internal spreadsheet. It's a formal legal record. Any member can ask to see it, and it lists who's on the board, when they joined, when they left, and even the shares they hold. It's a really basic but powerful tool for corporate transparency. And just to make sure companies take all of these procedures seriously, the law attaches penalties if they don't comply. These fines reinforce that every single step we've talked about, from filing the right forms on time to keeping that register of directors updated, isn't just a suggestion, it's legally required. Which really brings us to our final thought. We've walked through these 3 very different legal paths for a director's exit: the automatic, the voluntary, and the forced. The rules are clearly designed to create order and accountability. But the big question is, do they actually work? Or do they sometimes just become a complex rulebook for a well-timed, strategic exit? It's definitely something to think about. Thanks for tuning in.